volunteer training for community strengthening presentation. Title: Volunteer Training in Law, Working with Children in Victoria of Australia. Presented by Chuan Tat Kang, Kang Chuan Tat. The 23rd of July 2016. Employment. Reference: Kath Harper, Editor, 2000, Law Handbook 2001, Your Practical Guide to the Law in Victoria. Fitzroy Legal Service, Victoria of Australia. Community Services Act 1970, Victoria of Australia. Section 77 mentions that a child 12 years or over may have a licence to engage in street trading, but is not allowed to work after 11 p.m. or before 6 a.m. Important for those who a. sell paper on street corners and b. deliver newspaper. Community Services Act 1970, Victoria of Australia. Section 74G(2) says that it is an offence to employ a young person before school hours if that employment prevents the young person from taking part profitably in school lessons during the day. Community Services Act 1970, Victoria of Australia. Section 74G(3) Summary: a birth certificate or a certificate from a principal showing that the child is of permissible age is needed before a child under 16 can work in a factory. Education Act 1958, Victoria of Australia. Section 64M states briefly that the restrictions on the employment of young people do not affect work experience programs for those at school who are over 13 years of age or who are at least in the second year of secondary schooling. Subject to some limitations. Drinking and smoking. Drinking. Liquor Control Reform Act 1998, Victoria of Australia. Section 126 is regarding the demand of the name and address of a young person who requests or receives liquor by the police or the licensee's employees on licensed premises. Failure to give any information or the correct information is an offence. Liquor Control Reform Act 1998, Victoria of Australia. Section 128 says briefly that the police may seize and take away any liquor in the possession of a person believed to be under 18. Note: a person under 18 can be charged with being drunk and disorderly just as anyone can. Smoking. Tobacco Act 1987, Victoria of Australia. Section 12 prohibits the purchase of tobacco by a person under 18, or by a person for the use of a person under 18. Rights and duties at school. School attendance. Under Education Act 1958, Victoria of Australia, Section 3 and 53, a person is required to attend school from the age of 6 until reaching the age of 15. Exceptions: a child is ill or incapacitated, a child can be educated at home, and it is established that the child is under efficient and regular instruction. Community Services Act 1970, Victoria of Australia, Section 74G, says that it is an offence to employ within school hours, on any school day, a child not entitled to be exempt from attendance at school. special exemptions of attendance at school under Minister of Education in Victoria of Australia. 1. On the grounds of a parent's illness or severe hardship. 2. For a child over the age of 12 on the recommendation of a school medical officer for special treatment by a child psychiatric clinic. 3. On the ground that it is in the interests of the child to be exempted from school. Wills, tattooing, passports. Wills Act 1997, Victoria of Australia. Section 5 summarises that a person must be 18 or above to make a will. Tattooing. Summary Offences Act 1966, Victoria of Australia. Section 42 says that it is an offence to tattoo a person under 18. Passports Act 1938, Commonwealth Australia. Section 7 says that without the written consent of each person entitled to custody, guardianship or access, under such general rule, a passport will not normally be issued to an unmarried person under 18 with Australian citizenship. Exceptions. 1. A court has allowed the person to leave Australia. 2. The physical or mental welfare of the person would otherwise be adversely affected if a passport were not granted. 3. The passport is required urgently because of a family crisis and the person required to give written consent cannot be readily contacted. Marriage Act 1961, Commonwealth Australia. Section 12 says that a person aged 16 or the 17th of may apply to a judge or a magistrate for an order granting permission to marry a particular person of marriageable age. The marriageable age for both males and females is 18. Family Law Act 1975, Commonwealth Australia. Section 51 and Marriage Act 1961, Commonwealth Australia. Section 23. Marriage is not permitted where one party is already married or the parties are within a prohibited relationship, e.g., brother, sister. Prostitution Control Act 1994, Victoria of Australia. Section 5, 6, 7, 10. It is an offence to cause or induce anyone under 18 to take part in prostitution, whether as a prostitute or as a client. It is also an offence to receive payment knowing that it has been derived directly or indirectly from sexual services provided by a child, or to enter into or offer to enter into an agreement for a child to provide sexual services in return for payment in exchange for drugs. Prostitution Control Act 1994, Victoria of Australia. Section 13 and 15. A young person may still be charged with soliciting for the purposes of prostitution in a public place or being found in an unlicensed brothel. Giving evidence. Evidence Act 1958, Victoria of Australia. Section 23, 2A. A judge must not warn or suggest to a jury that the law regards children as an unreliable class of witness. Medical treatment. Medical treatment. Children and Young Persons Act 1989, Victoria in Australia, Section 271, 1 and 2. The Secretary of DHS, Department of Human Services in Victoria may order that a young person in his or her care or custody, or in the care or custody of a suitable person or community service, be examined to determine the young person's medical, physical, intellectual or mental condition. Arrangement may be made for the provision of any necessary medical, dental, psychiatric, psychological or pharmaceutical services to that person. Children and Young Persons Act 1989, Victoria in Australia, Section 271, in certain circumstances on the advice of a legally qualified medical practitioner, the Minister, the Secretary of DHS or any person authorised by the Secretary may consent to the medical treatment of a surgical or other operation, or the admission to hospital of a young person under certain children's court orders, including the young person undergoing sentence, even if the parent objects. Australian law in Victoria. Community Services Act 1970, Victoria in Australia. Children and Young Persons Act 1989, Number 56, 1989, Victoria in Australia. Children's Services Act 1996, Victoria in Australia, Number 53, 1996, Child Employment Act 2003, Number 81, 2003, Victoria in Australia. Children and Young Persons Amendment Act 1990, Number 93, 1990, Victoria in Australia. Historical Act. Photo. Voluntary tutoring for young persons. Relevant legislation. Employment. Community Services Act 1970, Victoria of Australia, Section 77. Permits and licenses. 1. Application for a permit or license shall be made in the prescribed form by or on behalf of the parent or guardian of the child. 2. The Secretary may grant a permit authorizing any child to engage in employment for the purposes therein specified, but no such permit shall be granted in respect of any child under the age of 7 years unless in the opinion of the Secretary special circumstances make it desirable so to do. 3. The Secretary may grant a license authorizing any child over the age of 12 years to engage in street trading. 4. The Secretary shall not grant a permit under subsection 2, or a license under subsection 3, unless he is satisfied a. that the health, education and moral and material welfare of the child will not suffer from such employment or street trading, b. that such child is fit to be so engaged, and c. that in the course of such employment or street trading the child shall not be subjected to any form of exploitation. 5. A permit or license under this section shall have effect for such times during such periods and subject to such conditions as are prescribed or as the Secretary specifies in such times, periods, and conditions shall be endorsed on or appended to the permit or license. 6. The Secretary shall not grant a permit or license authorizing any child to engage in employment or street trading after the hour of 11 o'clock at night or before the hour of 6 o'clock in the morning. 7. The Secretary may by notice in writing served on the parent or guardian of the child at any time cancel or vary a permit or license. Relevant legislation. Employment. Community Services Act 1970, Victoria of Australia, Section 74G. Employment during school hours of children of school age. 1. No person, including a parent, shall within school hours on any school day employ or permit to be employed any child of school age in any trade, business, work or occupation carried on for the purpose of gain unless such child has been exempted by the minister from attendance at school A on the grounds of illness or severe hardship to the child's parents, or B, on the ground that the child being of or over the age of 12 years has been recommended by the school medical officer for special treatment at a child psychiatric clinic approved by the minister, or C, on the ground that it is in the interest of the child to be exempted from attendance at school. 2. No person, including a parent, shall employ any child or permit any child to be employed on any such trade, business, work or occupation carried on for the purposes of gain if the nature and extent of the employment is such as to prevent the child from profitably taking part in school lessons. 3. Before any child apparently under 16 years of age is employed or permitted to be employed in any factory within the meaning of the Labour and Industry Act 1958, the occupier of such factory shall obtain from such child a certificate of birth or a certificate under the hand of the head teacher of the school which such child last attended, stating that the school records show that such child is of the age required under the said Act to permit of such employment, and every such certificate shall be filed by the occupier of the factory and shall be open to inspection of any person authorized by the minister. 4. Every person, including a parent, who in contravention of this section employs or permits to be employed any child in any trade, business, work or occupation carried on for purposes of gain, and every occupier of a factory who in contravention of this section employs or permits to be employed therein any child from whom such a certificate has not been obtained, or does not file or does not permit the inspection of any such certificate shall be liable to a penalty of not more than $200. Relevant legislation. Employment Education Act 1958, Victoria of Australia, Section 64M, certain laws, etc. Not to apply where employment is to gain work experience. 1. Subject to this part any act or law relating to the prohibition or regulation of the employment of children or young persons shall not apply to the employment of a child or young person who is a pupil at a school, and A, who is of or over 14 years of age, and B, who with the written consent of a parent is employed pursuant to a work experience arrangement. 2. Where any act or law prohibits the employment or regulates the working conditions in any specified trade, A, of persons of less than or not more than a specified age expressed as a number of years, or B, of females, then subsection 1 shall not be taken to permit the employment of any person contrary to that act or law. 3. For the avoidance of doubt, a permit under Division 2 of Part 2 of the Child Employment Act 2003 is not required for the employment of a child in accordance with a work experience arrangement, except as provided by subsection 4. 4. A work experience arrangement authorizing the employment of a child in a factory or in a class of employment declared to be dangerous employment under subsection 5 cannot be made unless a. the child is of or over 14 years of age, and b. a permit has been issued under Division 2 of Part 2 of the Child Employment Act 2003 in respect of the proposed employment. 5. The Minister, by order published in the Government Gazette, may declare any class of employment to be dangerous employment if, in the Minister's opinion, there is a higher than usual risk of a child being exposed to the risk of physical injury in employment of that class. 5a. The Minister, by order published in the Government Gazette, may from time to time amend or revoke an order made under subsection 5. 6. Where in respect of any trade the working conditions of young persons are regulated but the employment or working conditions of children are not specifically prohibited or regulated, a child may be employed in that trade pursuant to a work experience arrangement so long as the working conditions are those applicable to a young person. Relevant legislation. Drinking Liquor Control Reform Act 1998, Victoria of Australia, Section 126. Power to demand suspected minor to give his or her age. 1. If a police officer or a gambling and liquor inspector has reason to believe that a person appearing to be under the age of 18 years, 1. has requested or received a supply of liquor, or 2. has consumed, is consuming or is about to consume liquor, or 3. is on licensed premises or on any authorized premises, in contravention of this Act, or b. a licensee, permittee or employee or agent of a licensee or permittee has reason to believe that a person appearing to be under the age of 18 years is on the licensed premises or on any authorized premises in contravention of this Act, the police officer, inspector, licensee, permittee, employee or agent may demand particulars of the person's age, name and address. 2. If the Protective Services officer on duty at a designated place has reason to believe that a person at or in the vicinity of a designated place who appears to be under the age of 18 years has consumed, is consuming or is about to consume liquor in contravention of this Act, the Protective Services officer may demand particulars of the person's age, name and address. 3. This section is repealed by Number 92, 2004 Section 31. 4. A person must not a. refuse to give particulars of his or her age, name and address, b. give any false particulars of his or her age, name and address, or c. give any false evidence as to his or her age, name or address, pursuant to a demand made under this section. Penalty: 15 penalty units. 5. If a person refuses to give his or her name and address on being required to do so under this section, a police officer or a Protective Services officer referred to in subsection 2 may caution him or her, and if he or she persists in the refusal, may arrest him or her without a warrant. 6. If the Protective Services officer arrests a person under subsection 5, the Protective Services officer must hand the person into the custody of a police officer as soon as practicable after the person is arrested. Liquor Control Reform Act 1998, Victoria of Australia, Section 128, Seizure of liquor from minors. 1. If a police officer, a protective services officer on duty at a designated place, or a gambling and liquor inspector reasonably believes that a person under the age of 18 years is in possession of liquor in contravention of this Act, the police officer, protective services officer or inspector may seize and tip out or take away the liquor or cause the liquor to be seized and tipped out or taken away, together with any vessel containing it. 2. A police officer, protective services officer on duty at a designated place, or gambling and liquor inspector who seizes and tips out liquor under subsection 1 must do so as soon as is practicable after seizure. 3. If liquor is seized and tipped out under subsection 1, it is taken to have been forfeited to the Crown immediately before it is tipped out. 4. If liquor is seized and taken away under subsection 1, and the person from whom the liquor was seized is found guilty by a court of possessing the liquor in contravention of this Act, the court may order that the liquor be forfeited to the Crown or be destroyed or otherwise disposed of. 5. No compensation is payable by the Crown in respect of any liquor tipped out, forfeited, destroyed or otherwise disposed of under this section. Relevant legislation. Smoking. Tobacco Act 1987, Victoria of Australia, Section 12. Supplying tobacco to person under 18 years. 1. A person must not sell a tobacco product to a person under the age of 18 years. Penalty, in the case of a natural person, 120 penalty units. In the case of a body corporate, 600 penalty units. 2. A person must not purchase a tobacco product for the use of a person under the age of 18 years. Penalty, in the case of a natural person, 20 penalty units. In the case of a body corporate, 100 penalty units. 3. The occupier of premises on which a vending machine is situated must not permit a person under the age of 18 years to obtain a tobacco product from the vending machine. Penalty. In the case of a natural person, 60 penalty units. In the case of a body corporate, 300 penalty units. Relevant legislation. Wills. Tattooing. Wills. Wills Act 1997, Victoria of Australia, Section 5. Minimum age for making a will made by a minor is not valid. Tattooing. Summary Offences Act 1966, Victoria of Australia, Section 42. Tattooing of juveniles. 1AA. In this section, beading means the cutting of the skin of a person and the insertion of an object beneath the skin to produce a lump. Branding means the application of heat, cold or a substance to the skin of a person to produce scar tissue. Like process includes scarification, tongue splitting, branding and beading. Person means a living human being. Scarification means the cutting of the skin of a person to create scar tissue. Tongue splitting means the cutting of the tongue of a person to divide the tongue, or part of the tongue, into two or more segments. 1. Any person who performs any tattooing or like process on any person under the age of 18 years shall be guilty of an offense. Penalty: 60 penalty units. 2. Nothing in this division shall apply to any tattooing or other like process performed by or at the written request of a person registered under the Health Practitioner Regulation National Law 2. Practice in the medical profession, other than as a student. Relevant legislation: Marriage Act 1961, Commonwealth Australia, Section 12. Authorisation of marriage of person under age of 18 years in exceptional circumstances. 1. A person who has attained the age of 16 years but has not attained the age of 18 years may apply to a judge or magistrate in the state or territory for an order authorizing him or her to marry a particular person of marriageable age despite the fact that the applicant has not attained the age of 18 years. 2. The judge or magistrate shall, subject to subsection 4, hold an inquiry into the relevant facts and circumstances and, if satisfied that a. the applicant has attained the age of 16 years, and b. the circumstances of the case are so exceptional and unusual as to justify the making of the order, the judge or magistrate may, in his or her discretion, make the order sought. But otherwise the judge or magistrate shall refuse the application. 3. Subject to subsection 5, where a judge or a magistrate has made such an order, the person on whose application the order was made is in relation to his or her marriage to the other person specified in the order, but not otherwise, of marriageable age. 4. Where a judge or a magistrate to whom an application is made under this section is satisfied that the matter could more properly be dealt with by a judge or a magistrate sitting at a place nearer the place where the applicant ordinarily resides, the judge or magistrate may, in his or her discretion, refuse to proceed with the hearing of the application, but such a refusal shall not, for the purposes of Section 19, be deemed to be a refusal of the application. 5. Where an order is made under this section and the marriage to which the order relates does not take place within 3 months after the date of the order ceases to have effect. Family Law Act 1961, Commonwealth Australia, Section 51. nullity of marriage. An application under this Act for a decree of nullity of marriage shall be based on the ground that the marriage is void. Marriage Act 1961, Commonwealth Australia, Section 23. Grounds on which marriages are void. 1. A marriage that took place on or after the 20th of June 1977 and before the commencement of Section 13 of the Marriage Amendment Act 1985 is void where a. Either of the parties was, at the time of the marriage, lawfully married to some other person. B. The parties are within a prohibited relationship. C. By reason of Section 48, the marriage is not a valid marriage. D. The consent of either of the parties was not a real consent because 1. It was obtained by duress or fraud. 2. That party was mistaken as to the identity of the other party or as to the nature of the ceremony performed. Or 3. That party was mentally incapable of understanding the nature and effect of the marriage ceremony. Or E. Either of the parties was not of marriageable age, and not otherwise. 2. Marriages of parties within a prohibited relationship are marriages a. Between a person and an ancestor or descendant of the person, or b. Between a brother and a sister, whether of the whole blood or the half-blood. 3. Any relationship specified in subsection 2 includes a relationship traced through or to a person who is always an adopted child, and, for that purpose, the relationship between an adopted child and the adoptive parent, or each of the adoptive parents, of the child, shall be deemed to be or to have been the natural relationship of child and parent. 4. Nothing in subsection 3 makes it lawful for a person to marry a person whom the first mentioned person could not lawfully have married if that subsection had not been enacted. 5. For the purposes of this section, a person who has at any time been adopted by another person shall be deemed to remain the adopted child of that other person, notwithstanding that any order by which the adoption was effected has been annulled, cancelled or discharged, or that the adoption has for any other reason ceased to be effective. And b. A person who has been adopted on more than one occasion shall be deemed to be the adopted child of each person by whom he or she has been adopted. 6. For the purposes of this section, adopted in relation to a child means adopted under the law of any place, whether in or out of Australia, relating to the adoption of children. Ancestor in relation to a person means any person from whom the first mentioned person is descended, including a parent of the first mentioned person. Relevant legislation: prostitution. Prostitution Control Act 1994, Victoria of Australia, Section 5. Causing or inducing child to take part in prostitution. 1. A person must not cause or induce a child to take part in an act of prostitution, whether as the prostitute or as the client or in any other capacity, or to continue to take part in such acts. Penalty, Level 5 imprisonment 10 years maximum. 2. An offence against subsection 1 is an indictable offence. 3. In a proceeding for an offence against subsection 1a, it is not necessary for the prosecution to prove that the accused knew that the person concerned was a child, but b. It is a defence to the charge for the accused to prove that, having taken all reasonable steps to find out the age of the person concerned, the accused believed on reasonable grounds, at the time the offence is alleged to have been committed, that the person concerned was aged 18 years or more. Relevant legislation. Prostitution Control Act 1994, Victoria of Australia, Section 6. Obtaining payment for sexual services provided by a child. 1. A person must not receive a payment except in the ordinary course of a business unrelated to prostitution, knowing that it or any part of it has been derived, directly or indirectly, from sexual services provided by a child. Penalty, Level 4 imprisonment 15 years maximum. 2. An offence against subsection 1 is an indictable offence. 3. If in a proceeding for an offence against subsection 1, it is proved that the accused was residing with a prostitute who was a child, the accused must be presumed to be guilty of the offence in the absence of proof to the contrary. 4. In a proceeding for an offence against subsection 1a, it is not necessary for the prosecution to prove that the accused knew that the person concerned was a child, but b. It is a defence to the charge for the accused to prove that, having taken all reasonable steps to find out the age of the person concerned, the accused believed on reasonable grounds, at the time the offence is alleged to have been committed, that the person concerned was aged 18 years or more. Relevant legislation. Prostitution Control Act 1994, Victoria of Australia, Section 7. Agreement for provision of sexual services by a child. 1. A person must not enter into or offer to enter into an agreement under which a child is to provide sexual services to or for that person or another person in return for payment or in exchange for drugs of dependence. Penalty, Level 4 imprisonment 15 years maximum. 2. An offence against subsection 1 is an indictable offense. 3. In a proceeding for an offense against subsection 1a, it is not necessary for the prosecution to prove that the accused knew that the person who was to provide the sexual services was a child. But b. If the person concerned was aged 17 years or more at the time the offense is alleged to have been committed, it is a defense to the charge for the accused to prove that, having taken all reasonable steps to find out the age of the person concerned, the accused believed on reasonable grounds, at the time the offense is alleged to have been committed, that the person concerned was aged 18 years or more. Relevant legislation. Prostitution. Prostitution Control Act 1994, Victoria of Australia, Section 11. Allowing child to take part in prostitution. 1. A person who owns or occupies any premises or who manages or assists in the management of any premises must not allow a child to enter or remain on the premises for the purpose of taking part in an act of prostitution, whether as the prostitute or as the client or in any other capacity. Penalty, Level 5 imprisonment 10 years maximum. 2. An offense against subsection 1 is an indictable offense. 3. In a proceeding for an offense against subsection 1a, it is not necessary for the prosecution to prove that the accused knew that the person concerned was a child. But b. It is a defense to the charge for the accused to prove that, having taken all reasonable steps to find out the age of the person concerned, the accused believed on reasonable grounds, at the time the offense is alleged to have been committed, that the person concerned was aged 18 years or more. 4. If in a proceeding for an offense against subsection 1, it is proved a. that a child was on premises used for the purposes of the operation of a brothel and in respect of which a permit is required under the Planning and Environment Act 1987 for their use or development for those purposes, and b. that the child was on those premises for the purpose of taking part in active prostitution, the accused must be presumed to have allowed the child to enter or remain on those premises for that purpose unless the accused satisfies the court on the balance of probabilities that he or she did not know, and could not reasonably have known, that a child was on those premises for that purpose at the time the offense is alleged to have been committed. Relevant legislation. Prostitution. Prostitution Control Act 1994, Victoria of Australia, Section 11A. Child over 18 months not to be in brothel. 1. A person who carries on a business of a kind referred to in the definition of brothel in Section 3 or who assists in the management of that business. must not allow a child over the age of 18 months to enter or remain in a brothel at which that business is carried on for any purpose whatsoever. Penalty: level 8 imprisonment, 1 year maximum, or a level 8 fine, 120 penalty units maximum. 2. In a proceeding for an offence against subsection 1a, it is not necessary for the prosecution to prove that the accused knew that the person concerned was a child over the age of 18 months. But b. It is a defence to the charge for the accused to prove that, having taken all reasonable steps to find out the age of the person concerned, the accused believed on reasonable grounds, at the time the offence is alleged to have been committed, that the person concerned was aged 18 years or more or under 18 months. Relevant legislation. Giving evidence. Evidence Act 1958, Victoria of Australia. Section 23, Evidence of children and persons with a cognitive impairment. 1. Subject to this section, a child or a person with a cognitive impairment is competent and compellable to give evidence. 1a. A child or a person with a cognitive impairment is competent to give sworn evidence only if he or she is capable of understanding that, in giving evidence, he or she is under an obligation to give truthful evidence. 1b. Subject to subsection and c. A child or a person with a cognitive impairment who is not competent to give sworn evidence is competent to give unsworn evidence only if he or she is capable of understanding and of giving an answer that can be understood to a question that is put to him or her. 1c. If a child or a person with a cognitive impairment is not capable of understanding and of giving an answer that can be understood to a question that is put to him or her, that child or person is not competent to give evidence about the fact to which that question relates, but may be competent to give evidence about another fact that relates to a question which the child or person is capable of understanding and of giving to it an answer that can be understood. 1d. If a child or a person with a cognitive impairment is competent to give evidence, the court must, before the evidence is given, explain to the child or person in the absence of the jury, if any, a. the importance of telling the truth and of not telling lies, and b. that he or she may be asked questions that he or she does not know or cannot remember the answer to, and that he or she should let the court know if this occurs, and c. that he or she may be asked questions that make suggestions that are true or untrue, and that he or she should agree with the statements that are true and should not feel pressure to agree with statements that he or she believes are untrue. Relevant legislation. Giving evidence. Evidence Act 1958, Victoria of Australia. Section 23. evidence of children and persons with a cognitive impairment. 2. The competency of a child or a person with a cognitive impairment to give evidence must be determined in the absence of the jury. 2a. On the trial of a person for an offense, the judge must not warn or suggest in any way to the jury that the law regards children or persons with a cognitive impairment as an unreliable class of witness. 2b. Nothing in subsection 2a prevents a judge from making any comment on evidence given in the proceeding that it is appropriate to make in the interests of justice. 3. If any person whose evidence is received by virtue of this section gives false evidence in such circumstances that he would, if the evidence had been given on oath, have been guilty of perjury, he shall be guilty of an indictable offense. 4. Nothing in this section shall limit or affect the provisions of the Crimes Act 1958 as to the reception of evidence not on oath. 5. Nothing in this section shall limit or affect the operation of Section 102 of this Act. Relevant legislation, medical treatment. Children and Young Persons Act 1989, Victoria in Australia, Section 271. Powers of Secretary in relation to medical services and operations. 1. The Secretary may at any time order that a person, a, in the care or custody of the Secretary as the result of 1. An interim accommodation order, or 2. A custody to secretary order, or 3. A guardianship to secretary order, or b. In the legal custody of the secretary as provided by Section 253, or b. A. Placed with a suitable person or suitable persons or in a community service approved under Section 58, 1, as a result of an interim accommodation order, or c. In safe custody under Section 69. 79, 5, 83, and 488, 5, and 6, 95, 3, 95, 4, including sections 95, 3, and 95, 4, as applied to a supervised custody order by Section 98, 3, 110, 2a. 111, 3, or 111, 4, be examined to determine his or her medical, physical, intellectual or mental condition. 2. The Minister and the Minister administering Division 1 of Part 2 of the Health Act 1958 may make arrangements for the provision of any necessary medical, dental, psychiatric, psychological or pharmaceutical services to persons referred to in subsection 1 or to any class or classes of those persons or to any other persons placed in a community service. 3. On the advice of a legally qualified medical practitioner that medical treatment or a surgical or other operation or admission to hospital is necessary in the case of a child referred to in subsection 1a, 2, or 3, or b. The Minister, the Secretary or any person, other than an officer or employee authorized by the Secretary in that behalf, may consent to the medical treatment or the surgical or other operation or the admission to hospital even if the child's parent objects. Relevant legislation, medical treatment. Children and Young Persons Act 1989, Victoria in Australia, Section 271. Powers of Secretary in relation to medical services and operations. 4. The Minister, the Secretary or any person, other than an employee, authorized by the Secretary in the behalf, may consent to medical treatment or a surgical or other operation or admission to hospital in the case of a child who is not referred to in subsection 1a, 2, or 3, or b, if a, the child is placed in a community service or with a suitable person or suitable persons as the result of 1. Having been taken into safe custody under section 69. 79, 5, 83, and 4, 88, 5, and 6, 95, 3, 95, 4, including sections 95, 3, and 95, 4, as applied to a supervised custody order by section 98, 3, 110, 2A, 111, 3, or 111, 4, or 2, an interim accommodation order, and b. a legally qualified medical practitioner has advised that the medical treatment or operation or admission to hospital is necessary to avoid a serious threat to the health of the child. And c. the child's parent, 1. refuses to give his or her consent, or 2. cannot be found within a time which is reasonable in the circumstances. 5. An authorization under subsection 3 or 4a must be made by instrument, and b. may be made to the holder of an office or position or to any person for the time being acting in or performing the duties of an office or position. 6. An employee may, in accordance with section 7, have delegated to him or her any function or power of the Secretary under this section, except unless he or she is an executive within the meaning of the Public Administration Act 2004, the power to make authorization under subsection 3 or 4